So good morning, good afternoon, good evening, wherever in the world you might be. It's a pleasure to welcome you to this episode of We'll Work for Food, the New Possibilities Hour. Today is February 15th, 2024, and we're coming up on having a solid 4 years of these programs. And it's my pleasure today to let you know that the amount of donations of which we've been told is a whopping $525,316.17. That's probably well over 5 million meals, thanks to the generosity of the many speakers, the attendees, just all of us over time. So thank you so much. And I can see $1 million in the, not coming up. So thank you so very much. 600,000 will be the first next target. Today we've got another amazing speaker. They're all amazing, right?
It's Timothy Lawler.
And sorry about that. And this will be Matt is going to speak to us about insurance coverage issues. He's just come out of a trial, so he's in trial mode, and Matt's also teaches law school classes. He is an insurance coverage attorney in Southern California. He has lived here most of his life, out of Philadelphia before that. And as a practicing attorney, he has worked exclusively in the field of insurance, primarily in bad faith litigation. The practice has permitted him to gain experience in all aspects of insurance, including coverage, bad faith, trial, and appeals. And Matt is a founding member of the Southern California branch of Pacific Law Partners. He does have a life outside of the law, and we are very pleased and privileged to have him with us here today. So Matt, your food bank is the Long Beach Rescue Mission. That's the Long Beach, California. And so why don't you tell us a little bit about the Long Beach Rescue Mission, and then the floor is yours.
Thank you. The Long Beach Rescue Mission is a Christian-based mission located in Long Beach, California, that is intended to help the homeless in that area. Homelessness is an epidemic in the United States, and I know in other parts of the world. And I actually feel that it's somewhat embarrassing for such an affluent society as the United States to have so many homeless people. It seems like we should do more, but I think those efforts need to start more at the private level instead of relying on the government to do that. And that's exactly what the Long Beach Rescue Mission does. Prior to COVID, I guess I should say I've been donating funds to Long Beach Rescue Mission for a number of years. Prior to COVID, I also spent a lot of time working there. It was a great experience to get away from the law, to be cutting up carrots and celery in the kitchen in the morning, preparing for meals. And I also did some mentoring there because they have a program where they homeless people, both men and women, can live there and get educated, learn some kind of occupation, and get their faith in order. So I think the Long Beach Rescue Mission is a great place to donate to help with this homeless problem. For my time working there, I speak to a lot of these homeless gentlemen, mostly was who I was working with, and almost to a man, they were there because of some kind of drug-related problem. They were very clear in saying that. So these people need our help, and we should be giving that help. So whether it's Long Beach Rescue Mission or anywhere else that can provide food to those in need, I strongly encourage that. And if you want to get your mind off the law, go there and work and cut some carrots. It's it's a nice thing to do. It makes you not just feel good about yourself, but it helps you maybe see a bigger picture that we sometimes lose in our practice of the law. So as Jean said, I'm an insurance lawyer. I handle primarily insurance bad faith litigation, but that involves a big part of coverage. And I wanted to start today's discussion with an insurance coverage joke, but despite my scouring of the internet, I couldn't find any. And I can only assume that's because insurance coverage on its own is amusing enough that it doesn't need to have any jokes. So we'll skip right past that. So when I talk about a coverage case, I guess I'm going to clarify a few things. What I'm talking about is any case in which the insurance coverage may be in dispute. So a large part of my practice is doing defending bad faith litigation, and it's often in first party coverage disputes. So I deal a lot with homeowner property claims, and somebody has a claim that was denied for whatever reason, and the fight is over that coverage. But these same kind of coverage disputes could extend to third-party claims, such as a duty to defend issue, or whether there's coverage under the policy otherwise, some kind of liability coverage. And it can also extend to those situations in which you have insurers defending somebody, but the issue becomes whether there's going to be indemnity payment coverage for some kind of settlement. I think, generally speaking, what I'm going to talk about can encompass all those things. Before I get into it a little bit further, I do want to thank Tom Scuddy, who is on this Zoom. He's my uncle and also a friend, and he's an attorney and mediator. He saw that I was doing this, and he said, let me give you some notes and thoughts, because from the mediation point of view. So he gave me some great notes that, frankly, I'm going to use and rely heavily. As I mentioned, I just got out of trial, so we'll go forward and see how this goes, right? So why should insurance coverage cases be settled? Well, I'm actually a believer that all cases should be settled. Anybody who's been sitting at counsel table when the jury comes out and the clerk's about to read the verdict, you know that can be an exhilarating moment, but it can also be a heart-stopping moment. And fortunately, in the trial that I just concluded yesterday, we received a defense verdict. But I know that was what those 12 people thought. And another 12 people could think the exact opposite and have slammed me and my client. And so to avoid that situation, settlement is the best path for all involved. And I couldn't help but reflect this morning about the plaintiffs in that case, who are now, they lost. They not only have their own costs that they're dealing with, but they're going to have to face our costs. And it did give me a pause, and kind of looked at it from the other point of view, which is another reason why insurance cases should be settled. I am a Christian, unashamedly, so I will tell you that I thought it's interesting that Jesus actually tells us to settle lawsuits. So if you read in Luke chapter 12, Jesus says, as you go with your accuser before the magistrate, make an effort to settle with him on the way, lest he drag you to the judge and the judge hand you over to the officer and the officer puts you in prison. And the point being that if we can find a compromise, if we can find a resolution that you might not be happy with, but you are definitely going to be happier than the worst case scenario, that's where we should be heading. And this is especially true in the coverage case, because coverage issues as litigated often are a all or nothing approach from both sides. If you have a situation where the insurance company is saying there is no coverage, plaintiff is saying there is coverage, and you put that in front of a jury, you're either going to probably win big or you're probably going to lose big. So to mediate that issue is important, to try to find a resolution that everybody's happy with. So why should the plaintiffs settle? Well, the plaintiffs should settle because if there's truly a coverage dispute that could result in a denial of coverage from the jury, it gives them the opportunity, obviously, to get something without getting nothing. And they should consider doing this too far before they get too far into the dispute, because once they get too many costs involved, then it's going to be more difficult to settle that coverage dispute. The defendant should settle for the same reason, obviously, but the other thing that the defendant has to consider, the insurance company, is whether whatever you're going to do could end up making some kind of bad law in an appellate opinion or otherwise. So the defendant is protecting from both of those, as well as the cost that the defendant will incur as well. So let's turn to the concept of a coverage mediation. I think, like any mediation, a lawyer should take the following steps in preparing for that mediation. You need to prepare yourself, you need to prepare your client, you need to prepare the mediator, and you need to prepare your opposition. So let's talk about each one of those in turn. Prepare yourself. As the coverage lawyer, either on the plaintiff or the defense side, you need to know the law that is applicable to that coverage. Most coverage issues are replete with case law discussing that particular coverage issue or something at least similar to it. And if you're familiar with the law, you still should be making sure that you're up to speed on those coverage issues, the most recent cases, to see if there's something that you've missed that is recent, that hasn't come across your desk, or possibly if there's a case that is more on point with your facts or more on point with the relevant issues in your case. To this end, considering other jurisdictions can also be a strong point for you to use in mediation, because although you might not find an on-point case in your jurisdiction on the coverage issue, you certainly may find one in another jurisdiction that will help you with the thought process and the arguments behind those coverage issues. The second thing that the lawyer needs to know in preparation for the mediation, or to do in preparation for the mediation, is to know the facts. I know both of these, know the facts and know the law, seem quite obvious, but sometimes I've experienced myself when I've been in mediation and the other side doesn't know one or the other or either. So you need to make sure you have a full and firm grip of the facts, that you understand the important facts and can discuss them with ease. Because I think it's important to separate those important distinguishing coverage facts from just the other facts in the case. Remember, when we're talking about insurance coverage, generally what we're talking about is taking some fact and applying it to some policy language or a group of facts to policy language. So the facts become as important, if not more important, than the law. And you want to be able to narrow those facts down to the key facts. At the same time of this process, although I've talked about how I think every case should be settled, every case has to be thought of in mind as though you're going to try that case. And so I think that at this prospect of proceeding with mediation, it's an excellent time for you to also start thinking about your themes that you're going to be presenting in the case. I know we're not talking about trials here, but I think that a trial theme or themes, preferably themes, are paramount to get your jury to understand what can be complex coverage issues. So just as a recent example, the two themes that I pushed often in my trial yesterday was, number one, that people sometimes say things that they think they need to say to get insurance coverage. And number two, that the physical evidence in my case spoke louder than what people said. Those themes were the same things that I would want to present through the concept of a mediation, maybe not in such a pithy, clever way, but that same kind of concept moving forward. So know your facts and limit those facts to those key facts that are going to support your themes ultimately, because your themes are generally what you're going to want to use in mediation. And I think the last thing that the lawyer needs to do in preparation for the mediation to teach themselves what they need to know is to know their client's position. Now, that might seem a little bit obvious, but I think it's important to make sure you understand why your client thinks there is or there is not coverage. And this goes on both the plaintiff and the defense side. Because you're going to be advocating your client's position, obviously, but you also need to make sure your client's correct, right? So I have made it my own personal rule that anytime I get a coverage case, when I think the client's incorrect, I will tell them that they're incorrect, because I don't want to wait until the moment before trial and say, by the way, we're going to lose. Thanks for paying me for 2 years. Can I have money to settle the case? So I think it's important to make sure you understand where your client's coming from on coverage, and you need to look to see if they're correct or not. And then in that same process, you need to look for weaknesses in their position, because you know, or you should assume, that the other side is going to find those weaknesses. You need to look for those weaknesses and find ways to bolster those weaknesses as well as bolster your strong points. And in that same process, you need to make sure your client is correct, or maybe better stated, more accurate with the facts that your client thinks are important. Are those facts going to be provable for you? Can you present those facts with a straight face at mediation? And what themes you can derive from those. So I think that's the first step that the client needs to do, or I'm sorry, the lawyer needs to do in preparation for mediation. And I think this process really happens in advance of mediation, or it should, when any lawyer gets a case that involves coverage. But as you get closer to the mediation, you really want to make sure you're able to discuss your case freely, openly, without having to have your nose buried into your file. Now, the second step is to prepare your client. This, in some ways, can maybe be the most difficult step, because your client, in their own mind, is righteous in their belief that there is coverage or there is not coverage. And you probably need to at least temper that expectation somewhat. I think this is particularly important for the plaintiffs, to have them prepared for mediation, because typically when we're talking about an insurance coverage dispute, on one side you have a plaintiff who likely has had as much litigation experience as the insurance company. The insurance company is generally going to be very familiar with this. So you need to make sure that your plaintiff understands the process, because the insurance company will, understands questions that may be asked, how to respond, when to respond, and they need to make a good impression, because facts are paramount for coverage issues, and credibility is ultimately the most important part when it comes to those facts. Now, that doesn't mean that the defense side doesn't need to prepare their attendee for mediation. Any of you that have ever worked for an insurance company knows that, unfortunately for the coverage lawyer, you don't always have the person attending the mediation that's the person that did the coverage work, or that did the investigation, or even is the one that might have the purse strings that need to be loosened. So whenever I have a mediation, I schedule a meeting with my client, or I'm sorry, with the person attending the mediation, my client, to prepare them for the mediation, so that they're familiar not only with the case, which I assume at some point they will get on their own, but also so that they're familiar with the mediation process. While the insurance company generally is familiar with litigation, the mediation process, that doesn't necessarily mean all of their employees are. So I need to make sure that they are well prepared, just as the plaintiff is, so that I have the same expectations for them as to when to answer questions, how to answer questions, and that they too are making a good face for the insurance company. One of the things I always want to promote in trial and in mediation is insurance companies, despite the bad press, are a group of people, right? They're a group of people working toward whatever their goal is. And so you want to present those people just like you would present the plaintiff. So it's important for both sides, the plaintiff and the defense, to schedule a pre-mediation call to discuss with them the process and get their expectations about mediation, and possibly most importantly, to answer any questions they may have about the mediation process, so that they're ready going into it. I generally tell my clients, and those of you that are mediators might not like this, but I generally tell my clients to be cautious when they answer questions. If they feel the slightest bit of a lack of comfort in answering a question posed to them, to say, I'd like to talk about that with my lawyer, and so we can talk about it, and then they can answer or I can answer. I think it helps. Obviously, I'm trying to put the best defense forward. The plaintiff's trying to put their best case forward. But I think it also can keep the issues a little bit clearer and not get so caught up in somebody that maybe says something incorrectly or goes about it the wrong way. The last and most important thing, I think, in preparation for preparing your client for mediation is to prepare them to compromise. So obviously, you go to a mediation to compromise. It's not very likely that you're going to walk in a mediation and you're going to pay or accept what your first number is, if that number is anything. If that were the case, you wouldn't be at mediation. People spend a lot of money, with all due respect to mediators, people spend a lot of money to go to mediations, and you're only going to do that if you're willing to compromise. And there's many times I get into mediation where I feel like the plaintiffs themselves have not been informed of that sufficiently. and they're stuck on what they want instead of finding a number that makes everybody unhappy, which is what we should all be looking for. A couple other points I think that are important for virtual mediations, which I think are almost the exclusive way of mediating nowadays. I don't even remember the last time I've been doing in-person mediation. Those need to be, your virtual mediation needs to be as professional as it could be as if you were in person. So you need to tell your client in preparing them for mediation that they can have no distractions. There shouldn't be kids running around, people asking the questions, phones ringing, things of that nature. They also need to at least present a business casual look, I think, not necessarily a suit and tie, but look like, you know, you're there for something important. You know, the old saying is dress for the job that you want. Well, I think the same applies for mediation. Dress for the settlement that you want. Because you're making some kind of impact on the people that are viewing you. So your clients need to make sure that you're doing that. And make sure that they're there to pay attention, because they're going to learn about the mediation process. They're going to learn about their case, what's good about it, what's bad about it, and they need to pay attention to that. And they need to listen to what the mediator says. And if they're distracted, then they're not going to do that. Plaintiffs especially should make sure they're not doing it on their phone or in their car or at work or at the park or at Starbucks. I mean, certainly some people don't have the ability to attend a Zoom mediation other than through maybe some of those things. But if they can avoid it, it's better to have them have their FaceTime on a computer instead. And allow your mediator to spend time with your client. So I think this is probably more important on the plaintiff side, because I think most mediators understand that the lawyer is really speaking for the insurance company in the defense side. But on the plaintiff side, I think it's important for the mediator to be able to return to the defendant and say, hey, this guy or this gal is going to be a good witness. They, you know, they can state their position. They've got the facts straight. They're not exaggerating. All of those things I think are important. Allowing the mediator to spend time with your client as the plaintiff allows the mediator to get questions answered in a non-confrontational way, which is important because the case will get confrontational after that. I also think there's the ability to let the plaintiff get it off his or her chest, so to speak. So they want to be heard. One of the reasons they file a lawsuit is they want to be heard, and that can give them the opportunity to be heard and move past that to reach a settlement. One thing that, well, many of these things have been recommended by Tom Scuddy, as I mentioned, but one thing that he recommended as a mediator, I may disagree with him a little bit on this one, but is to consider a joint session. I'm frankly not too much of a fan of a joint session, but he brought up an excellent purpose for a joint session, and that's if the plaintiff has not been deposed. It can be very helpful for the defense to see that plaintiff, to hear that plaintiff, to hear what they have to say, to give their own evaluation on it. All of this will be done under the mediator's confidentiality provision, so the defendant or the insurer, they can speak with each other. They can speak with the plaintiff. They can speak with the plaintiff's lawyer. It allows the lawyer to gauge credibility, which I think is important, and witness potential, to see if the lawyer thinks that that could be a strength for the plaintiff moving forward, or for the plaintiff's lawyer to present their claim as a strength. Because I said before, we're applying facts to the law. Well, facts come through testimony, and testimony is impacted by credibility. So that credibility is important for the other side to be able to evaluate. So I think that Tom has opened my eyes to the necessity of a joint session on occasion. And I have had occasions where joint sessions have been successful to the mediation. It has to be the right case, and it has to be the right parties, because people have to go into the joint session with an open mind to be able to discuss freely, but not walk away insulted. And I often think that connection between the parties can help bridge the gap. So the next step, I think, is to prepare the mediator. Now, you know, most often in an insurance coverage context, your mediator is going to have at least a talkable ability to discuss coverage. They're certainly, but the thing that lawyer needs to remember is you cannot expect that mediator to know the coverage like you do. That's unfair, because They're mediating many different kinds of cases, and you are handling this particular case. So a few steps to that I think are important. First of all, I cannot understate the importance of a brief in a coverage mediation. I think that the mediation brief is paramount for a few reasons. Number one, you need to have the policy language in front of the mediator. But you don't want to slap a 45-page policy to your mediator and say, the policy language is in there, you find it. Or especially the way that most policies are written, when you have endorsements that modify parts of the policies, you'd have to tell them, turn to page 30, then you need to turn to page 5, then you look to page 8. You're making your mediator's job very difficult. So put the applicable policy language right into the brief. And then talk about, like I said before, the important facts. Your mediator doesn't want to read 8 pages of facts about the insurance company called them on this date. On this date, they returned the call. We don't need to hear all that. Those things aren't important. Just put those coverage facts in there so we can get to the root of the case. You want your brief to be well written, of course, and you want to provide it to the mediator well in advance so that the mediator has the ability to look at it and then call you up and discuss it with you if appropriate. This also, I will get to the point about discussing, preparing your opposition, but getting the brief to your opposition in advance is also an important step. So this means, of course, that the brief should be shared if possible. I'm not a fan of confidential mediation briefs because I really, frankly, don't get the point of them except in some very limited circumstances. But there's no reason why you should be afraid of telling your opposition why your case is good and why you're going to win, and put that in writing so they can consider it. There's nothing to hide. People are going to figure out how they can attack it after the mediation if they just get it later in the case. So give it up front so you can give your mediation the best chance of success. There's no reason to keep your coverage position to yourself. Now, if you have something that's confidential for whatever reason, maybe the insurance company knows a fact or a witness that they don't want to disclose yet, or maybe there's some kind of other, let's say, nefarious thing going on the insurance company wants to hold back, or maybe the plaintiff has information or damages they don't want to fully discuss yet. You can do that in a separate confidential letter or a separate confidential smaller brief to your mediator. But you shouldn't let your entire position be hidden just because you have a few pieces of confidential information. So back to educating your mediator, as I said, the brief should include your applicable policy language and any relevant case law construing that policy language. And put up the bad case law too, and discuss why it's not applicable, or how you're going to get around that, or why there's another case that better supports your position. And don't be afraid to use out of jurisdiction case law, because it can be very persuasive. And often when people write coverage opinions, they rely on case law from multiple jurisdictions because of the thought process that can go into it. For the plaintiffs, do what the insurance company does when you're preparing the mediator. That's apply the facts to the policy language and argue why there is coverage or why there's not coverage. Don't just argue. Don't just say there's coverage because there is coverage. You need to do the same thing. The plaintiff needs to do the same thing that the insurance lawyers are doing. That's the way you're going to be able to convince the insurance company to give you money. And I know that's what the plaintiff wants to do. Early briefing also gives you the chance to have a pre-mediation conference with the mediator. So that allows the mediator to get a full understanding of the relevant issues, and more importantly, probably to focus on the key issues. You can write the best brief in the world, but it's much easier to say to your mediator, hey, look, there's no coverage for this because this guy said this, bam. And put it in that context so it's easy you can narrow it down, boil it down to the key points. Your mediator will have time to digest the more fine points, the more points that don't seem as relevant on their face, and those are certainly important to be discussed and considered at mediation. but you want to give the mediator a chance to talk with you about it in a way probably you're going to want to talk to a jury about. You want to make sure the mediator has full understanding of the issues and focus on those key issues. Sometimes coverage cases will go off on tangential coverage issues that aren't really the key coverage issue, right? So let's focus on the key coverage issue. We don't need to talk about whether the person qualifies as an insured unless whether they qualify as an insured is an issue. If they do, you don't need to mention it or argue it or whatever. Just let's get to the key issues here. And then tell the mediator the arguments you have in support and or against coverage, and maybe those things that you think are your weaknesses. It allows the mediator time to educate him or herself in the law or in the nuances of the law, the nuances of the case. Because it's very unlikely the mediator knows the law as well as you do, especially since you've probably, or if you've done what I've recommended, you've recently researched the law and will be able to talk about it better than the mediator will probably know it. And you certainly will know the facts better than the mediator. So it's important to have that conversation with the mediator. The next step is to prepare your opponent, which I think that some people may think is an unnecessary step because you may expect your opponent to be prepared. But I think it's important to have a fruitful mediation to make sure the other side knows where you're coming from. So for the plaintiffs, my recommendation to the plaintiffs is that by the time of the mediation, the defendants, or I should say the insurance company and the defense counsel have probably done a thorough legal and factual evaluation of the case. You have to remember how the insurance company gets to a mediation generally is they're going to have had reports written. They're going to probably have had at least one conference call to discuss the case with the people that understand the issues. They're going to be prepared in that way. You as the plaintiff need to be prepared in the same way to have a thorough legal and factual evaluation. If you're not, if the plaintiff's lawyer is not prepared to do the same thing, you're ultimately just hurting your own credibility. Because remember, as the plaintiff, you're trying to convince the insurance company to give you money, and they're going to give you money for one of two reasons. Basically, number one, you've convinced them that you're wrong on the coverage position, or they're wrong on the coverage position, which is good for you, yay you, which is also probably the less likely of the other two, or the other one, which is that you're going to at least give them some doubt in their coverage position. Maybe it's not a slam dunk that they thought, and you want to be able to be the one as the plaintiff's lawyer to get them there. The insurance company has already decided on coverage, right? I mean, that's why you're there. If they thought there was coverage, they would have paid. So they've already decided there's not coverage. You need to try to change their mind, and that means you need to convince them to do that. Now, both lawyers, the plaintiff lawyer and the defense lawyer, as I said before, should share their brief. There should be nothing confidential, generally speaking, on a coverage position. And if there is, do it in a separate brief or letter, or maybe even in that phone call with your mediator, as long as you're telling the mediator, hey, I want to tell you something, but please don't reveal this unless or until I tell you it's okay. The reason, I know I talked a bit about this already, about sharing the briefs and not making them confidential. But one of the reasons for that is not the time to surprise somebody on the coverage issue. You don't want to walk in and say, hey, I just learned this and there's coverage. If you are the plaintiff and you do that, it's very unlikely you're going to be able to get the defendant to pivot that quickly, because they've already done their workup on the case, right? So you're not going to be able to walk in and say, hey, here's this fact, there's coverage, give me all my money. So you need to make sure that you give, as the plaintiff, you need to give the insurance company and the defense lawyer time to review and digest whatever you're saying is the reason for coverage. The insurance company process, generally in my experience, to go into a mediation is going to require multiple steps. Typically, from the defense point of view, we're providing some kind of initial evaluation report when we get the case or get the claim. So that's the first step that the insurance company is going to get the lawyer's point of view on coverage. The second step is there's generally going to be some similar, maybe a little boiled down preparation for the mediation, where you're telling your client, you know, here's where we are in the case. Here's anything new or different that I've learned. And here's why I think we should settle or not settle, or how much we should settle for. And then the last step typically for insurance companies is that there will be a conference call with the people, the powers to be, so to speak. If you as the plaintiff wait until the day before mediation or the day of mediation to share your brief or to tell your coverage position, you're not giving your opponent the chance to get money. As the defense lawyer, I've told plaintiffs' lawyers this numerous times. If you want me to pay you, help me. I need to be able to go back to my client and say, here is why you should pay these people. And if you don't help me with that, if you don't tell me why you think that there's coverage and convince me at least that I think that there's a chance that I'm going to lose, you know, nobody's getting that money for you. So you need to help me do that. And I always think that, you know, the work is going to get done anyway. So if you share your coverage position well in advance, or if you share it the day before, all you're doing is making that defense lawyer stay up late investigating your coverage position, putting them in a bad mood for your mediation instead of doing it far in advance so that they can be prepared, because they're going to get the work done. It's the one thing with insurance lawyers is they get the work done, because we're fortunate enough to be paid hourly. So we get the work done. Support your brief with evidence. This is on both sides, plaintiff and defendant. And I think this is particularly important in coverage because, as we said, facts determine coverage, and you want to be able to show the other side what those facts are or what that evidence is. So do that with photographs, videos, reports, receipts, testimony if you have it in depositions or recorded statements or even some kind of declaration. Show them what you will later prove if they don't settle. Show them what you're gonna show the jury at trial. Show them your best evidence. You don't have to show them all of it. That doesn't really advance the ball very far. But show them your best evidence. One thing that's really frustrating to me is when we get to mediation and then suddenly somebody wants to show me an estimate that they have, or some receipts, or a photograph that would change a coverage position. That's not going to help me whatsoever. I'm not going to be able to do anything with that information then. And it really has made our mediation a waste of time in many ways. So give it to the other side in advance so they have the ability to consider those things. Coverage, as I said, is a fairly equally mixed facts and law. So you want that well-written, logical brief supported by that evidence to let the other side recognize that they're going to have a fight on their hands, that this is not going to be as easy as they thought it was, and that maybe they're going to end up in an appeal on this. It could be something that would be especially important to the insurance carrier if they want to avoid making bad law. Frankly, that's probably something insurance companies want to avoid more than anything, because bad law will impact many more coverage situations than just settling your case. So as the plaintiff, if you think that you have that type of case that's going to lead to some kind of law that the insurance companies are going to be not particularly happy with, then tell them that, show them how that's going to happen. And you're going to likely give you the opportunity to get a good settlement out of it. So I wanted to turn the last step into, before I'm going to end my discussion with things I don't like hearing and things I do like hearing at mediation, my pet peeves and those of people in my firm, because I kind of took a survey of what they like to hear in coverage mediations and not. I wanted to talk about negotiations, because I think the negotiations should be different in a coverage case than maybe other types of negotiations. I think in the client's mind, you need to get your client to understand that their negotiations should be with a consideration that they might lose, not that they might win. Because if they're considering that they might win, I think that their number on either side is going to be it's going to be off-putting for the other side. Common sense may say to give your biggest or your lowest number, but if you're interested in settling, I think that gets you nowhere. And frankly, when I get a big number that is not in recognition of the settlement, I ignore it. I don't even consider it as something that has any value for my negotiation. If I get a number that's not within the realm of reasonableness, I'm going to just negotiate from my own position, not from yours, until you get into what I think is a more reasonable number. So to that point, I think that both the plaintiffs and the defendants need to negotiate as though you might lose. You can still do this from a point of strength. I'm not saying you immediately capitulate, but your number needs to recognize that there's a chance that you could get nothing. To this point, this is maybe a little bit unfair for me to say because I'm coming solely from the defense point of view. But if the insurance company offers you anything, they are already taking that step toward recognizing that they might lose. So at a very base level, the plaintiff thinks that they are right on coverage, so they think they're entitled to recover all of their damages and maybe more extra contractual damages if that's your case. But the insurance company thinks that they're right on coverage. They will want to pay nothing, right? If there's no coverage, they think there's no reason to pay. You have to remember that insurance companies come from the idea that the policy as a contract is the agreement between the parties. And not only is that an important part of the negotiations between the parties, but the insurance company owes a duty to all policyholders to only pay claims that are covered. So because of that, the insurance company wants to just pay what is covered. That doesn't mean they won't pay if it's not covered. It just means that they want to not pay. So when they offer any money, they've already taken a step towards saying, I understand that we might lose. In this process, one thing that can be difficult, and I know is off-putting to insurance companies, is when we hear about your costs as the plaintiff. I often hear when the plaintiff says, well, I can't settle because we've got these costs X, Y, and Z. I understand that those are facts to be dealt with and they have to be considered in the settlement. I'm not being naive in that way. But I often hear from insurance companies that they will say, well, we're not going to compensate you for the privilege of suing us. So just because you've decided to file a lawsuit, whether it has merit or not, that doesn't mean that we're suddenly going to pay for you suing us. So all of these things need to go into the analysis, and your demands and your response to demands and offers should show, most importantly, that you're listening and recognizing the issues. So as this proceeds, as each side makes points and steps in the process, you need to have your numbers match that process so that you're getting closer together and you're reducing your numbers based on the fact that it could be or could not be coverage. One thing that is exceedingly frustrating to me is when I know that we make a good point on coverage and I see no response from the plaintiff. That either tells me that they're not listening, that they don't want to listen, or don't understand the coverage. So maybe that's my fault that I haven't adequately explained it to them. But the mediation is only going to result in a settlement. Mr. Obvious right now is if the parties can find a middle point, and that middle point is only going to happen when everybody recognizes that they might win or they might lose their case. That's the only way you're going to get closer to each other. So I think that both sides need to say that in their numbers. All right, so I'll end with, so I can leave some time for questions, although Tom promised me he would not ask any difficult or embarrassing questions. I'll leave you with a couple maybe pithy thoughts about what defense lawyers want to hear and what we don't want to hear. What I want to hear at mediation is what evidence actually creates coverage. I want to hear from you, for example, well, the plumber stated X, Y, and Z in his deposition, and that's why there's coverage for this water loss. I want that precise factual information so that I can use that to help me convince my client that we're gonna need to pay this claim, or we need to pay more than what we wanted. I also want a recognition from you of possibly losing, as I mentioned before. I want to see that recognition in the settlement demands. I don't want to give you information as to why you're going to lose, and then I see nothing in response, because you're not helping me get anywhere, and you're not getting anywhere, and we're just wasting everybody's time. The defense, remember, is showing you by offering any money at all that their recognition of losing. Of course, as I mentioned before, I want to know that case law and evidence showing coverage, even if it's only a colorable argument. Even if it's only a peripheral argument, or maybe an argument that hasn't necessarily been addressed by the courts, I still want to know what your argument is so I can understand it. I want a specific breakdown of your damages. I want to know where your numbers come from and why that number is important to me, and how that number will impact the case when I lose, if I'm going to lose. And most importantly, I want some recognition of the arguments that I present. Not just because I'm an egomaniac, but because I want to know that you're listening to what I'm saying. What I don't want to hear, this is maybe when I hope not to offend anybody, any of the plaintiffs lawyers out there. I don't want to hear, my client has paid premiums for 20 years and they never had a loss, so you should pay us. Insurance does not change. The contract does not change depending on how long you are insured, sadly. Maybe somebody could invent an insurance contract that does that maybe has some kind of changing language over the years. But you've probably received other benefits over the years of being insured. But remember, insurance is a gamble. And just because you're paying into the system doesn't mean you automatically get it out. So I don't need to hear that your client has been insured for 20 years. I probably already know that, and it has not advanced the needle at all for me. So you don't need to tell me that. I don't need to hear, hey, jurors dislike insurance companies. Yeah, we already know that. Being in front of jurors and questioning them for voir dire, I've only had one juror ever raise his hand because I generally will start to loosen them up a little bit by saying something like, who here likes insurance companies? And I actually had one juror raise his hand one time and then tell us about how the insurance company treated him really well, and he was a big fan of insurance companies. Of course, he didn't last on the jury very long. But I don't need you as the plaintiff's lawyer to tell me jurors dislike insurance companies. Trust me, I know it. I don't need to hear about the cost of litigation for the defense side. Remember, insurance companies are very sophisticated litigators. They litigate often. They don't need to know that the case is going to be expensive to litigate. We know that. And to give you a little bit of view behind the curtain, most insurance companies require a budget from the defense lawyer at the beginning of the case. So the insurance company has a really good idea of how much it's going to cost to defend the case. I don't need to hear that. And the last thing I don't want to hear is clever, or maybe not so clever, mocking of insurance company slogans. So I do a lot of work for State Farm, and I've been in countless mediations where I see in the brief or hear somebody say, State Farm wasn't like a good neighbor on this case. All right, I get it. Yeah, that's clever. You're going to tell the jury that. I don't need to hear it. I know what their slogans are, and that's not going to advance the coverage position to me whatsoever. So you can keep the good neighbor to yourself, or hi, this is Jake from State Farm. I don't need to know any of that. Let's just talk about the coverage issues. So with that said, that's all I got. Thank you for your time today and listening to one boring insurance defense lawyer talk about coverage. And I'd be happy to take any questions that are not too complicated and not from Tom Scotty.
Thank you so much, Matt. This was fascinating. And I loved your laundry list of things that you didn't want to hear. For me, it was always the cost of defense kind of argument. You know, when the mediator would come in and say that, it's like, no, that's not going to get my client to settle the case. Let's not do that. Let's not go down that road. So does anybody have a question for Matt? It's a great opportunity to see how the defense thinks on this. Okay. You know, one thing I would say there are some questions here in the chat, or some discussion anyway, about the mediation brief. And we had a prior guest a couple of years ago, Jonathan Teller, who's a plaintiff lawyer, And he said that he always trains his lawyers to send the mediation brief to the defense counsel, and some of these cases were bad faith cases, to the defense counsel a month in advance, because he recognizes that insurance companies need the time to maybe roundtable the case, and the defense lawyer needs time to look at the arguments and all of this. And so while in the chat it's talking about 1 week to the mediator, which I have no problem with, sooner is better. And sharing mediation briefs, I think, when you're in coverage litigation, at least for the facts and the issues, is very helpful. I'm sure that you would say that too, Matt, with the private stuff directly to the mediator then.
Yeah, I agree. And one thing I'd like to do too, Gene, is I just like to ask the mediator, when do you want the brief? Because mediators are all different. And you know, in the process of litigation, I mean, we calendar a million things, right? So why not calendar when the mediator wants the brief? And then you're giving the mediator the opportunity to, I know mediators don't advocate, or not to advocate on our behalf, but you're giving the mediator the opportunity to be able to discuss with the other side the issue of why they should settle. There's a great question in the chat, Gene, I saw about compulsory mediations, which is a really good question, because I was primarily focusing on mediations when both parties are agreeing to mediate. And so there's at least some desire to reach the middle ground, but we do get many compulsory mediations. One thing I do compulsory mediations, if we are in a strong coverage position, is I will tell the other side, you know, you're not really going to hear much from us at mediation other than nuisance value, because I don't want to create an expectation. I don't think it's fair to create an expectation. I just want them to know going into the case that, like, hey, you've got an uphill battle. Right now, I don't see any reason for my client to pay you anything more than a nuisance value. Of course, nuisance value is variously defined depending on the case. But I tell them that because I think it's fair. I try to be a straight shooter, and I don't want the other side to think, you know, that they're going to go into a compulsory mediation getting a lot of money. Now, from what I'm going to tell my client is I'm going to tell them why they should settle the case, and maybe point out the weaknesses that the other side hasn't necessarily pointed out yet, because I don't want my client to be surprised later. That's part of my job, is even if the plaintiff has not done their job to tell me why we could lose on the coverage, I need to tell my client why we could lose on the coverage, and therefore use that to maybe get more money than the client wants to pay. But the fact of the matter is, compulsory mediation sometimes can be nothing more than a very brief mediation for that exact reason. The parties, however, should go into the mediation willing to listen still, and willing to change their mind. I had an extremely frustrating situation about half a year ago on a mandatory settlement conference, which is obviously like a compulsory mediation. And we went into the mediation. It's a coverage dispute, which we were going to offer nuisance value. And the plaintiff's lawyer demanded, like, I can't remember the exact number, but it was the damages are small in this case, probably about $75,000, but it's a bad faith case. The plaintiff's lawyer started the demand at $500,000. And we responded with some kind of nuisance offer of like $2,500 or something like that. I don't remember exactly. Well, the plaintiff's lawyer came back and said, nope, that's not good enough, offer us more. At which point I said no, and then MSC was over. So that was frustrating. But what's even more frustrating is later that day, I received a statutory offer from the plaintiff's lawyer for $75,000. Now, I understood why he was doing that, in the sense that he was saying, this is our damage, and we're trying to set that up for later. But if you're willing to settle for $75,000, then make that demand at mediation. Oddly, the same lawyer then sent another statutory offer a week later for $50,000. So I thought that was an extreme example of somebody wasting the opportunity of a compulsory mediation, because frankly, we might have been able to settle either at the MSC or later if he had acted reasonably. So the moral of the story is be prepared to compromise and be prepared to do your best even at those compulsory mediations, because sometimes those compulsory mediations will set up a future settlement. And that case is still being litigated now and likely will go to trial, I think in part because the lawyer, his negotiations didn't help the process.
Okay, we've got a lot of questions and not much time, so 3 minutes here. There is one question here, maybe you can answer quickly. Do you expect value calculations for settlement? Do you find it persuasive if the plaintiff presents expected value in a realistic way?
Yes, absolutely, because that goes into the equation. I don't necessarily deal with it as a percentage, but if they can show that their damages are $250,000 and I believe I have a 25% chance of losing, then I'm probably going to want to recommend more to my client than if they tabled less damages or my percentage was higher. But what's important is that same expected value calculation needs to happen early in the process, so I can bring it to my client, so I can at least prepare them to give me maybe more money than they're expecting.
Right. How serious do insurance companies take bad faith claims? Does it make sense for the plaintiff to include that if it's not a clear-cut case for it? And we're down to 2 minutes.
Yeah. Insurance company takes bad faith claims very seriously because the extra contractual component. So if you think of it this way, the contract is going, if there's coverage, the contract should be paid, and that coverage is presumably already within the insurance company's coffers, right? So they've reserved that money in essence for that loss. Extra contractual dollars is kind of them taking it out of a different pocket, which they don't like. So they do take it very seriously. I am not an advocate for you claiming bad faith when there is none. But certainly if you feel the insurance company unreasonably handled your claim, that's the bad faith standard in California anyway, then you should be suing the insurance company for bad faith. It's not necessarily going to get them to change their coverage position, but it does give them a bigger number that they may be dealing with if they lose on the coverage.
Thank you so much. It's the top of the hour. Matt, thank you. It's been a pleasure having you. Thank you all. Please be generous, as you always are, with your donations, whether it's the Long Beach Rescue Mission or your local food bank. And then please let Natalie or Jeff or myself know the amount of your donation. We'll be very glad to add it to our running total. Thank you all so much. See you next week, same time, same place. Thank you again, Matt. Bye. Thank you, everyone.
Thank you, everyone.